Hello everyone, I'm Sidhant. Today the chapter 4 of the legal of JAIIB examinations will be discussed. The chapter 4, the name is returns, inspection, winding up, mergers and acquisitions. First, the introduction. We'll try to make you understand the meaning of these terms, like what is returns, what is inspection, what is winding up, mergers and acquisition, etc. I think the best way to approach the JAIIB examination is to understand the topics and then solving the question bank as much as possible. This is the best way to approach this examination. So this is what I am doing. I am explaining or make you understand the basics or terms that is required to understand the questions when it comes in the examination. So the basic understanding plus the amount of questions you solved from the question bank or any other internet sources, you will able to gain as much confidence to score very good marks in the examination. So what is returns? The returns are nothing just to inform that something is complied of. For example, that as in the previous chapter we have read that the bank has to file a return of many things like the saving bank account amount, the fixed deposit amount, and the reserves or the assets they have to file a return periodically or annually as prescribed by the RBI. So this is returns. And inspection. What is inspection? Inspection is the power which is granted to the RBI under section 35 of the Banking Regulation Act. Here the RBI can demand any records or any files which is required to inspect with. The RBI can do so at any time and or scheduled. It can be both. The next, winding up. What is winding up? If some company is got bankrupt, and since we are discussing in the banking sector, so if banking company got bankrupt, then the next procedure that is done is winding up. That the closing of everything, the assets, liabilities of that company is winding up. Mergers and acquisition. The acquisition is of takeover of one company taken by another company, that is acquisition, or the government. And what are mergers? The mergers, as recently announced by the government of India, the Vijaya Bank, the Bank of Baroda and the Dena Bank, all three are merged into one, and this is nothing but a mergers. So the next topic is annual account and the balance sheets. First, you must understand what is annual account, what is the need, and what is balance sheet. Then you will proceed in the chapter. What is annual account? The annual account consists of the profit and loss account, the cash flows, and other statement which shows the financial condition of the banking at a particular year. And what is balance sheet? As the name suggests, balance means the balance of the asset and the liability in a sheet. That is, in any sheet, the balance of the asset or the liability the company had at a particular time is a balance sheet. And there are some requirement. Under section 29, the banking companies have to file the annual account or the balance sheet annually or quarterly or monthly as demanded by the institutions which required to have it as its norms. So for example, the CAIIB ordered that every banking company which have their shares in the market, they have to file this annual account and the balance sheet, annual account quarterly, the annual report, that is called annual report, quarterly they have to file to the CAIIB, and conditioned that this annual account and the balance sheet is signed by the 3 directors at least plus principal officer. And this annual account and the balance sheets are also given to the RBI, registrar of the companies, and it will be presented at the AGM, that is annual general meeting. And but these companies are they have to file annually. That in short, that quarterly they have to deposit it to the CAIIB and annually to the Reserve Bank of India, registrar of the companies, or AGM, that is annually general meeting of the company. Next topic is audit and the auditors. In the previous topic, where we have understood that annual account and balance sheet need to be filed to the Reserve Bank of India or CAIIB, then this accounts or the balance sheets must be audited at any particular of time. Generally it will be done annually, and where it is being mentioned that to have this audit, it is mentioned at the section 30 and section 31B. Section 30 is the simple audit and section 31B is the special audit done by the Reserve Bank of India. Next topic is submission of returns. What all things that the bank has to file the return. The list are the return of the liquid assets, that is NDTL, that we have studied in the previous chapter. The account and the balance sheet, they have to file the return. Assets in India and unclaimed deposit, they have to file this return. These all returns are generally annually. And CRR and SLR, but CRR and SLR is not annually, as we had discussed in the last chapter. CRR the second alternate fortnight and SLR is monthly. And the return of the liquid assets, that is NDTL, it's mentioned in the section 24 part 3 and 27. And the assets the banking company has in India, they have to file this return under section 25(1). And the unclaimed deposit, which goes to the DEF account, they have to file this return under section 26. The next topic is preservation of records and return of the paid instruments. Before 1985, there were lots of aggression took place because the banking companies are not keeping the records what they are doing. So after that, the court ordered to the central government to file some regulations or rules regarding this. So the central government comes up with the banking companies preservation of record rules 1985, as well as for the cooperative banks, the cooperative bank preservation of record rules 1985. Again, there are some other act which particularly specifies to have the record for some particular time, is the Prevention of Money Laundering Act 2002, which says to keep the records at least for the 5 years even after the end of the relationship with the bank or the depositor. And under section 45Z, even paid instrument can be returned only after true copy is taken by that particular banking company. The next topic in the queue is inspection and scrutiny. First of all, I will tell you what is the difference between the inspection and the scrutiny. RBI are empowered to do both the inspection and the scrutiny, but the inspection are for more than 1 day, and these are already scheduled by the Reserve Bank of India, but the scrutiny are not particularly scheduled, and it's a very instant process that they have to visit and do the inspection or scrutinize the data or records or person for a very short period of time and then come with the particular report. And the other differences is that the inspection is mentioned under section 35 and the scrutiny is mentioned under section 35(1)(a). And other differences is that inspection can be ordered by the Reserve Bank of India itself or the central government. If the inspection is done by the Reserve Bank voluntarily, then they have to file the inspection report to the bank to whom the inspection is going on, as well as to the central government. But it's optional that RBI can give this inspection report to the central government or not. But if central government ordered that inspection to conduct at a particular bank, then RBI has to file the two inspection report. First will be given to the central government and another will be given to the particular bank on which the inspection had done. The next topic is Board for the Financial Supervision. In the previous topic we have discussed about the inspection and scrutiny. Then who is conducting this inspection or scrutiny on behalf of the Reserve Bank of India? These are no one other than the Board for Financial Supervision. These are part of the main central board of the Reserve Bank of India. The RBI structure is like that. The RBI has the central board, which has the governor, deputy governors, local governors, additional directors, etc. And with that central board, there are different kinds of other you can say it as sub boards, and these boards are entitled or entrusted with some powers to do these things. So the Board for the Financial Supervisions are empowered to do the inspection and scrutiny, and it is being assisted by the Department of Supervision. The Department of Supervision is one of the department of Reserve Bank of India. I am telling these terms are important. The questions are asked in this by taking these terms one way or to the other. So this Board for Financial Supervisions is under Rule 4 of the RBI Regulation 1994. This is mentioned in the Rule 4 of the RBI Regulation 1994, and it is also mentioned in the Section 58 of the Reserve Bank of India Act. Though Reserve Bank of India Act is not very important, but some section like this, Section 58 of the Reserve Bank of India Act, is important. Things in this is that composition. The governor, the deputy governors, some deputy governors plus 4 directors are participated in this, and it has also one chairman. Might be the deputy governor is a chairman, and it has to report to the central board on the half yearly basis, and meeting at least once in a month and it has executive committee and advisory committee to help at for the particular things or purposes. Executives do the execution part, and the advisory committee advises on some particular points or norms. The next topic is acquisition of undertaking. There are 4 sections is very important in this acquisitions of undertaking. First of all, the acquisition of undertaking is nothing but a nationalization of the bank, what has been done in the 1969 or 1970 by the Indira Gandhi government. So the government has power to acquire or undertake any private banking businesses into its government undertaking. It can be done under section 36AE. By the power of exercising 36AE, the government can undertake any private banking businesses to the government undertaking. And what are the grounds that through which the government can undertake the banking businesses? Is that the non-compliance of the section 21 and 35A. We already have understood that what is section 21, what is section 35A. And for the always that public interest. And how these acquisitions of undertaking can be done? As we know that the private companies or any public companies which already have the shares with the owners, and taking that company from that owners, then the government has to pay the amount that is the market value of that part at a very particular time. Then there might be some conflict between the owners or the government, so they are well placed procedure which is being followed by the bank. They offer a scheme which is mentioned under section 36 AF. The scheme consists of everything, that how much shares they will give, how much amount per share they will gain from the government, or what are the policies and how can they be, what are the voting rights after that undertaking, and all will be taken care by the scheme. Again, the next section which is important is 36 AG. This is the compensation to the shareholder. Compensation, why the compensation? Because my shareholders might be in a very good positions to run that bank, but if since the government wants it for the public interest or for the public good, then they have to pay the amount that is the shareholders of that banking companies. So this is 36 AG, which is the compensation to the shareholders. And the next 36 AH, if the conflict doesn't resolve and the government is adamant to do the undertaking, then that shareholders can go to tribunal under section 36 AH. The next topic is amalgamation. Amalgamation is nothing but the combining of the two or more banking companies into one is amalgamation. It can be done either voluntarily, if some two bank wants to merge to itself, then they can do, or it's compelled by the government. So and if it's voluntary, it is mentioned under section 44A, and if it's by the government, then it is mentioned under section 396 of the Companies Act. So it is not important, but I mentioned it. And how the amalgamation is done, since the bankers or the bank has to comply so many of norms, so if they are combining in itself, then some of the others laws or rules can be broken. So there is a time called a moratorium is given to that particular bank to organize the scheme. Scheme is organized in that 6 period, and then it is sent to the government, and the government approved it, sanctioned it, then it will be ineffective. So the point is that the moratorium is given by the Reserve Bank of India to draw the scheme, which is, or the scheme is itself drawn by the Reserve Bank of India for that particular bank. The next topic is winding up. If the company is not healthy enough to run in the to run the banking businesses in India, then they have to do the winding up. The winding up can be done by the Reserve Bank of India under section 37 and or by the High Court itself under section 38. For the winding up, the official liquidator is appointed by the central government under section 38A. The next topic is penalty. What if the bank is not complying the norms? What if the company is not following the direction of the Reserve Bank of India? Then there is a provision of penalty in it by the Reserve Bank of India, or under the by the Reserve Bank of India under the RBI Act or the Banking Regulation Act. If they are not complying or not showing at the time of the inspection scrutiny the records that the RBI wanted, then they can be fined the 2,000 at each offense plus rupees 100 per day if they are not able to produce the particular record. For the amount of days that they are not producing, it will be multiplied with 100 with the days they are not producing, and 2,000 plus 100 with each offenses. If they conduct let's say 5 offenses, like they are doing the fraud, or they are not complying the one of the rules, or they are not able to produce the records, then with 3 offenses that have to separately give that 2,000 per offense plus 100 with each day delaying that particular record or something that is not produced to the Reserve Bank of India. And if the penalty is also mentioned in the Banking Regulation Act, the amount is much more higher than in the Reserve Bank of India Act, that is 50,000 they have to produce for each offense plus 2500 per day. Though in some of the offenses they have a minimum amount, they have a lower amount like 2000 plus 100 days criteria that is being applied in the Reserve Bank of India is also available in the Banking Regulation Act, and these all depends on the Reserve Bank of India how they will penalize that particular bank. That's all for it. If some penalty is being applied and they want to appeal it, they can do so under section 47 or 47(4), or the RBI under section 47 part 4 can impose the penalty to the banking companies. Thank you. I want to correct one thing, that section 47(4), the 47 relates to the court magistrate can penalize the bank, and 47 part 4 RBI can impose a penalty on the bank. This is something I want to correct. Thank you.